as Marina have already mentioned, since 2022, Russia has been actively developing anti-sanctions legislation, and it is quite numerous normative acts. It consists of presidential decrees, resolutions of the Russian government, and clarifications of the Bank of Russia and the Ministry of Finance of Russia. And of course, not to forget resolutions of the Government Commission for the control of foreign investments. There are numerous restrictions and peculiarities of certain transactions that are established by all this legislation, and most all of them concern so-called unfriendly foreigners, that is persons from the countries which are included in the list established by the Russian government. So when we are talking about unfriendly persons, we are just borrowing the rhetoric of the Russian legislation. We don't mean any negative connotations. There are numerous restrictions. For instance, people have to use special bank accounts. They are obligated to repatriate and to sell foreign currency proceeds. There are limits on certain transactions, and they require special permissions. Such permissions can be granted by several bodies, several governmental bodies. First of all, it's the Government Commission on control over foreign investments, then the Ministry of Finance and Central Bank of Russia. So in today's presentation, I'll briefly outline the main aspects to which, in my opinion, attention should be paid when doing business in Russia in the sanctions era. And let's start with currency legislation. First of all, I'd like to note some positive tendencies, such as relaxations in currency control rules for foreign trade contracts. From the 1st of April, foreign trade participants should not submit documents to the banks for transactions that don't exceed 1 million rubles. Previously, this limit was 600,000 rubles, so it's a good tendency, I think. Moreover, payments may be made not only through an authorized bank where this particular contract is registered, but through any Russian bank. According to Russian currency legislations, residents are required to repatriate funds received under foreign trade contracts in accordance with the conditions of such contracts. And this concerns both export and import contracts in case when obligations have been fulfilled under these contracts, and when, for example, advances should be returned because the obligations weren't fulfilled. However, since the summer of 2022, the requirement to return proceeds under foreign contracts was temporarily abolished. There are some exceptions. For example, sale of foreign proceeds is still mandatory for certain exporters, such as companies in fuel and energy sector. But these are not very much exceptions. And yet other companies still need to make sure that the obligations under foreign contracts are fulfilled on time, because the abolition of the requirement to repatriate funds is, as I said, is only a temporary measure. And after the expiration of that measure, the state authorities will still be able to bring the offender to administrative and also criminal liability. In this regard, it also should be noted that the moratorium on prosecution for violation of currency legislation has not been extended for 2024. So it's probably worth to keep in mind. Going further, there are several restrictions with regard to credits and loan agreements. Loans in rubles can be granted to friendly foreigners without any limitations. And There are also no restrictions for granting loans in rubles to unfriendly foreigners that are controlled by Russian persons or by friendly persons, provided such control occurred after the 1st of March 2022, and Russian tax services are aware of the existence of such control. There are also no restrictions for granting loans in rubles to Russian residents that are controlled by unfriendly foreigners. However, one will need permission of the Government Commission to grant loans in rubles to unfriendly foreigners and to grant loans in any foreign currency to any foreign persons, including friendly foreigners, so persons from China, from Kazakhstan, and so on. However, Russian residents are free to receive any new loans from any foreigners in any currency and also receive payments under existing loan agreements from any foreigners in any currency, because our state, of course, encourages the flow of funds into the country. Russian residents are also allowed to repay the loans to friendly foreigners or to unfriendly foreigners, which are controlled by Russian persons or friendly persons again. As for repayment of loans to unfriendly foreigners, there are no limitations unless the amount of 10,000 rubles or the equivalent 10 million rubles or the equivalent of this amount per month is exceeded. In this case, if the sum exceeds 10 million rubles, repayment of loans should be made to C-type account. It is a special account in rubles opened in a Russian bank by the Russian resident, but in the name of an unfriendly foreigner, of an unfriendly creditors. And if Russian resident pays money to this account, he is considered to be to fulfill the obligation in a proper way. So there will be no sanctions, no penalties, and so on. However, the use of this money and disposal of this money on the C-type accounts is very limited. So foreign creditors cannot transfer money from this accounts to normal, so-called normal bank accounts. For that, they will need also the permission of the Government Commission. They only could transfer this money between their own C-type accounts, but not to C-type accounts of other persons. And funds on these C-type accounts can be used only for limited purposes, for example, payment of taxes, fees, and other obligatory payments. Not for current expenses, not for business activities, and so on. The funds on these accounts can also be used for so-called exchange of frozen assets, but I will talk about it a little bit later. Another option will be to receive the permission of the Government Commission to transfer funds directly to the foreign account of unfriendly creditors. These restrictions apply also not only to payment of loan and credit agreements, but also to the termination of obligations in any other way, for example, by way of set-off, novation, transfer of debt, assignment of debt, and so on. However, there is silver lining, at least for Russian debtors, because obligation can be terminated through forgiveness of debt, and there will be no restrictions. So foreign creditors could forgive debt in amount over 10 million rubles per month, provided there will be no counter provision on the part of the Russian debtor. So if the foreign creditor will receive no benefits from this forgiveness of debt, then it is allowed, and no permission is required for such transactions. Going further, there are some restrictions with regard to payment of dividends and distribution of profits of Russian companies to foreign shareholders. Basically, there is a similar procedure. There are no restrictions to pay these dividends to friendly foreigners or to unfriendly foreigners controlled by Russian persons or friendly persons. As for other unfriendly shareholders, there are no limitations if the sum of the dividends paid doesn't exceed 10 million rubles per month. And if this threshold is exceeded, then the money should be paid to C-type account in rubles. It should be mentioned that this limit 10 million rubles, or the equivalent in the currency, it is the aggregate amount for dividend payment and loan agreement to all unfriendly creditors. So, for example, if Russian resident will repay the debt to Belgian person in amount of $5 million, 5 million rubles, then he only can pay 5 million rubles, another 5 million rubles to foreign unfriendly shareholders, so that in total there will be no more than 10 million rubles. There are also two options to pay the dividends directly to a foreign bank account of unfriendly shareholder, but both of these options require the permission of the Government Commission or the Ministry of Finance. In the first case, it will be necessary to fulfill some criteria. For instance, the amount of dividends should not exceed 50% of the net profit of the Russian company for the previous year, and the history of dividend payments for previous periods should be taken into account. Moreover, the foreign shareholder should prove that he is going to continue commercial activities in Russia. But it's not all. The supervising ministry will also have to evaluate the significance of the Russian company, its activities, and its impact on the Russian economy, and the opinion of this body will also have to be taken into consideration. The ministry should also confirm that the Russian company the ministry should also confirm that the Russian company has achieved key performance indicators, and most probably the dividends won't be paid in a lump sum, but will be paid quarterly, provided the Russian company still continues to fulfill these KPIs. Second option would be the payment of dividends in connection with the investments that have been made by the foreign shareholder. Such investments may include expansions of production or some innovative technologies, and they should be made after the 1st of April 2023. In that case, foreign shareholder will receive the dividends, but their amount won't exceed the amount of such investments he has made. Going further, there are several restrictions for the concluding of transactions with real estate, with securities, and shares in the Russian limited liability companies. Mostly, these transactions, when they involve foreign persons, they generally would require permission of the Government Commission or other bodies, but there are numerous exceptions. Basic exception both for real estate and securities is that the transactions won't require any permission if they are concluded with the persons controlled by Russian persons or friendly persons again. And of course, information on such control should be disclosed to tax services. There are also special exceptions, and a lot of them concern real estate. The first one is when the real estate is located abroad and settlements are made through foreign bank accounts. But information on resident bank accounts, again, should be disclosed to Russian tax services. Second exception is that unfriendly foreigner is allowed to sell real estate, provided the settlements are made through C-type accounts, so the money actually doesn't leave Russia. Next, unfriendly individual or legal person legal persons are also allowed to buy real estate so that the money will be back to Russia again, and spouses or close relatives are allowed to conclude gratuitous transactions between one another. There are not so much exceptions for the securities. However, there are several still. For example, transactions between residents and unfriendly foreigners can be made with regard to foreign securities if settlements are made through foreign bank accounts, so that the transactions is concluded outside of Russia. And second possible exception, I would say so, is exchanging of frozen assets. It concerns transactions in respect of foreign securities owned by residents and placed to foreign accounts of the National Settlement Depository, which are blocked due to sanctions, as you probably know. In theory, unfriendly investors could buy these funds, these assets, using funds from C-type accounts. But this idea has so far been provided only in Russian legislation, so there is a presidential decree in that regard. But as far as I know, foreign partners are not ready to participate in this process yet. So when there is no permission of the Russian bodies will be required for these transactions, assets still will be blocked on the NSD account, and still one still needs to require some license from the European regulators. So we'll see whether this process will be started and how successful it will be. Going further to the transactions with the shares in Russian limited liability companies, any transactions between residents and unfriendly foreigners directly or indirectly resulting in establishment, change or termination of rights to own, use and dispose of shares in such companies, or other rights that allow to determine the terms of management of such companies or the terms of their activities, normally would require the permission of the government commission again. There is, of course, exceptions. Gratuitous transactions between individuals are allowed, provided that these individuals are spouses or close relatives, and the result of such transaction is termination of the unfriendly foreigners' right with regard to limited liability company. But generally, one will need the permission of the government commission, and for that purpose, it will be necessary to submit a number of documents to relevant body. Normally it would be the Ministry of Industry and Trade, Ministry of Construction, Ministry of Digital Development, depending on the company of the Russian company's line of business. And among other things, it's necessary to provide the report on independent assessment of the market value of Russian company. Such assessment should be made by an appraiser from the list of the Ministry of Finance. In addition, it's necessary to have expert opinion to this report. Expert opinion should be given by an expert of self-regulatory organization, again from the list of organizations approved by the Russian Ministry of Finance. Furthermore, shares should be sold at the discount at least 50% of the market value of the Russian company. And voluntary contribution to the budget should be made. The amount of such contribution should be at least 15% of the market value stated in the appraiser's report. Then some key performance indicators for the target should be established and revealed to the ministry. And if there will be option agreement for the seller to buy back the share, such rights should be exercised during 2 years from the initial transactions, and the share should be bought back at the market value established later at the point of conclusion of the share purchase agreement. Finally, settlement under such transactions should be made through C-type accounts, or if purchase price would be transferred to foreign accounts of the seller, then SPA should contain installment payment clause. There are some relaxations regarding the intragroup transactions and transactions between unfriendly persons. In that cases, there would be necessary report on anti-payment assessment, and KPIs also won't be established. Generally, the idea is that intragroup transactions won't lead to the change of ultimate control of the Russian company. So in case of management buyout transactions, all these documents will still be necessary because the owner of the company will be changing. And transactions between unfriendly persons outside of Russia might include some deals with relation to the foreign holding company who has some subsidiaries, among them in Russia.
Maria,
And
could you finish in 2 minutes?
Yeah. Finally, a couple of words on the transfer of funds abroad. There are some restrictions for residents and non-residents. They concern transfer of money in foreign currency received as dividends and profits from Russian companies, payment for shares in the capital of foreign legal entities, payment of contributions under partnership agreements, if the amount of such a payment will exceed 15 million rubles. However, there are no restrictions to transfer foreign currency to the foreign bank accounts of branches and representative offices of the Russian companies. And finally, some exceptions, some restrictions for foreigners. Unfriendly foreign legal persons are not allowed to transfer funds abroad altogether, and foreign individuals may transfer funds abroad in the amount of their salary, provided they are working in Russia. Otherwise, they are not allowed to do that either. I think that was all from our part. I would like to hear some questions probably later. Thank you.
Thank you, Marian. Definitely, we will have some questions to you. At least I have a couple of them. And now, I would like